Legislature is back in session. Mr. Majority Leader.
Mr. Speaker, we have exhausted items on the second reading file, and I move that we go to the third reading and voting file.
Any objection? Hearing none. The first bill on the agenda is Bill number 3. Madam Clerk, if you'd read the title, please.
Bill number 3-34 COR, introduced by BJF Cruz, an act to amend sections 4301A and 4302C2 of Article 3, Chapter 4, Title 4, Guam Code Annotated, relative to ensuring that only the most economical and beneficial health care insurance proposal plan for Government of Guam employees, retirees, and foster children is forwarded by the Government of Guam Health Insurance Negotiating Team to Imagalahan Guahan for consideration, and to divesting Legislaturan Guahan of final approval authority over any contract entered into by Imagalahan Guahan for the same.
Roll call.
Senator Atta. Yes. Senator Atta, aye. Senator Uggan. Senator Uggan, nay. Senator Castro. Senator Castro, nay. Speaker Cruz.
Aye.
Speaker Cruz, aye. Senator Espadon. Senator Espadon, aye. Senator Esteves. Senator Esteves, nay. Senator Lee. Senator Lee, aye. Senator Morrison. Senator Morrison, nay. Senator Muña. Senator Muña, nay. Senator Nelson. Senator Nelson, aye. Senator Rodriguez. Senator Rodriguez, nay. Senator San Augustine. Senator San Augustine, nay. Senator San Nicolas. Senator San Nicolas, pass. Vice Speaker Terlahi.
Aye.
Vice Speaker Terlahi, aye. Senator Torres. Senator Torres, aye. Senator San Nicolas. Senator San Nicolas, pass. Senator San Nicolas. Yes. Senator San Nicolas, aye.
Bill number 3 received 8 ayes, 7 nays. Bill 3 is duly passed by the 34th Guam Legislature. Bill number 4, Madam Clerk.
Bill number 4-34 COR, as amended by the Committee on Appropriations and Adjudication, introduced by Frank B. Uggan, Jr. An act to amend Section 1 of Public Law 32-208 to add a new Section 1106.1 to Chapter 1 of Title II, Guam Code Annotated, and to add a new Section 1103 to Article 1 of Chapter 1 and a new Section 2100.1 to Article 1 of Chapter 2, both of Title V, Guam Code Annotated, relative to excluding Imagalahan Guahan, Isagundu Namagalahan Guahan, and Senators of Legislature Guahan from the Competitive Wage Act of 2014 and to reducing the salaries of the same.
Roll call.
Senator Adda. Senator Adda, nay. Senator Uggan. Senator Uggan, aye. Senator Castro. Senator Castro, nay. Speaker Cruz.
Aye.
Speaker Cruz, aye. Senator Espadon. Senator Espadon, aye. Senator Esteves. Senator Esteves, nay. Senator Lee. Senator Lee, aye. Senator Morrison. Senator Morrison, nay. Senator Muña. Senator Muña, nay. Senator Nelson. Senator Nelson, aye. Senator Rodriguez. I'm sorry, Senator. Senator Rodriguez, aye. Senator Snogstein. Senator Snogstein, aye. Senator Nicholas. Senator Nicholas, aye. Vice Speaker Talahi.
Ungan.
Vice Speaker Talahi, aye. Senator Torres. Senator Torres, aye.
Bill 4 received 10 ayes, 5 nays. Bill 4 is duly passed by the 34th Guam Legislature. Bill number 9, Madam Clerk.
Bill number 9-34 COR, as amended on the floor, introduced by BJF Cruz. An act to amend Section 6101L of Article 1, Section 6302 of Article 3, and Article 4, all of Chapter 6, Title 11, Guam Code Annotated, relative to clarifying the definition of electronic cigarettes and raising the minimum age of legal access to tobacco products and electronic cigarettes to 21 years, and to cite this act as the Youth Protection Act of 2017.
Roll call.
Senator Adda. Senator Adda, aye. Senator Uggan. Senator Uggan, aye. Senator Castro. Senator Castro, aye. Speaker Cruz.
Aye.
Speaker Cruz, aye. Senator Espadon. Senator Espadon, aye. Senator Esteves. Senator Esteves, aye. Senator Lee. Senator Lee, aye. Senator Morrison. Senator Morrison, aye. Senator Muña. Senator Muña, aye. Senator Nelson. Senator Nelson, aye. Senator Rodriguez. Senator Rodriguez, aye. Senator Snogstein. Senator Snogstein, aye. Senator Nicholas. Senator Nicholas, aye. Vice Speaker Talahi.
Aye.
Vice Speaker Talahi, aye. Senator Torres. Senator Torres, aye.
Bill 9-34 received 15 ayes. Bill 9 has been unanimously passed by the 34th Guam Legislature. On the nominations, all those in favor of Francisco G. Santos to serve as a member of the Guam Port Authority Board of Directors, please indicate by raising your hand.
Mr. Speaker.
Majority Leader,
I ask for a roll call.
there's been a request for a roll call. Do I have a second? Third. Senator Nelson. Senator Siniclas. Roll call.
Senator Adda. Senator Adda, nay. Senator Uggan. Senator Uggan, aye. Senator Castro. Senator Castro, aye. Speaker Cruz.
Nay.
Speaker Cruz, nay. Senator Espadon. Senator Espadon, pass. Senator Esteves. Senator Esteves, aye. Senator Lee. Senator Lee, pass. Senator Morrison. Senator Morrison, aye. Senator Muñoz. Senator Muñoz, aye. Senator Nelson. Senator Nelson, pass. Senator Rodriguez. Senator Rodriguez, aye. Senator San Augustine. Senator San Augustine, aye. Senator Siniclas. Senator Siniclas, pass. Vice Speaker Talahi.
Pass.
Vice Speaker Talahi, pass. Senator Torres. Senator Torres, nay. Senator Espadon. Senator Espadon, pass. Senator Lee. Senator Lee, pass. Senator Nelson. Senator Nelson, nay. Senator Siniclas. Senator Siniclas, pass. Vice Speaker Talahi.
Nay.
Vice Speaker Talahi, nay. Senator Espadon. Senator Espadon, aye. Senator Lee. Senator Lee, nay. Senator St. Nicholas. Senator St. Nicholas, nay.
On the nomination of Francisco G. Santos to serve as a member of the Guam Port Authority Board of Directors, there were 8 ayes, 7 nays. Mr. Santos has garnered sufficient votes for confirmation by this body. All those in favor of William D. Nault to serve as a member of the Guam Visitors Bureau Board of Directors, please indicate by raising your hand. Mr. Nault received unanimous confirmation by this body. All those in favor of Raymond H. Schnabel to serve as an insurance banking representative, Guam Banking and Insurance Board, please indicate by raising your hand. Mr. Schnabel has received unanimous confirmation by this body. All those in favor of Candy C. Okuhama to serve as a member of the Alcoholic Beverage Control Board, please indicate by raising your hand. Ms. Okuhama has received unanimous confirmation by this body. All those in favor of Mr. Earl J. Garrido to serve as a member of the Cockpit License Board, please indicate by raising your hand. Mr. Garrido has received unanimous confirmation by this body. I believe those are all of the nominations that I have. Any member wish to be heard on extension of remarks? If not, Senator Nicholas.
Thank you, Mr. Speaker. Mr. Speaker, I will not mince words. This was a very rough session for me. It was rough because it was just very profound in some very deep and meaningful ways. I had a measure on the floor that was put back to me. It was put back to me because, well, the rationale was that apparently more input was required. All the proper procedures were followed. The measure was noticed, it was heard. Because certain interested parties communicated after the fact, my measure was sent back. And in the course of the discussion, I was just further bothered because issues were raised with respect to my measure that I was not able to address or try to ameliorate in a closing statement or in any kind of fashion thereto. And it was just so bothersome because I just don't like the idea of the record reflecting one side. And I just found it so ironic that the very motion and the rationale to put it back to me in order to get more perspective was done, and it cut off my perspective here on this floor on my own measure. Resolution 27-34 was very profound for me the other day because in the middle of it, the judgment came down on the Davis versus Guam Election Commission et al. Case. And the whole rationale for why I moved forward Resolution 27-34 was I'm always a big believer in the fact that as long as we can have a multifaceted approach to securing as many rights for our people as possible, we're going to hopefully score some points, put some points on the scoreboard, because we haven't put any points on the scoreboard since 1950. Perspectives over those years, those last 67 years, have come and gone. Ideas on how to proceed have surfaced and been tried, and just recently in this Davis case been rejected. As an investment advisor, Mr. Speaker, I can tell you that the surest way to reach your goal is to diversify your path to it. And if we want to pursue a path of more rights for our people, it's safer for us to diversify that path. The ruling, and I'll read the conclusion into the record. The court recognizes the long history of colonization of this island and its people, and the desire of those colonized to have their right to self-determination. However, the court must also recognize the right of others who have made Guam their home. The U.S. Constitution does not permit for the government to exclude otherwise qualified voters in participating in an election where public issues are decided simply because those otherwise qualified voters do not have the correct ancestry or bloodline. Having found that the classification is racial, this court finds that the plebiscite statute impermissibly imposes race-based restrictions on the voting rights of non-native inhabitants of Guam, in violation of the 15th Amendment. Further, the court also finds that the plebiscite statute violates the 14th Amendment. And because the 15th and 14th Amendments are clearly violated in this case, the court need not address the statutory arguments that were raised by the plaintiff. The court hereby orders the following: plaintiff's motion for summary judgment is hereby granted. Resolution 27-34 seeks to use that very same constitutional argument to get us more rights. If the argument is that we cannot take this path because of the Constitution, surely we should use that very same argument to try and get more rights for our people if we can. There's a misnomer that the attainment of additional rights is going to somehow compromise the cause for self-determination. But realistically, Mr. Speaker, we sit here in this very hall because of an organic act that was created by Congress. The citizenship that we have, the passports that we all carry, those are all rights. And none of those rights ameliorate our right to self-determination. In the committee report, there's a very extensive work provided in that's going to be published in the Stetson Law Review. And on page 10, it speaks about something that I think is highly relevant. It talks about suffrage. Because citizenship and enfranchisement are not coextensive in our constitutional framework, the extension of the franchise and the development of a right to vote have occurred piecemeal through the process of constitutional amendments. At the founding, the right to vote was limited essentially to property-owning, tax-paying white males over the age of 21. Today, there is universal adult suffrage. African Americans were granted the right to vote in 1870 with the ratification of the 15th Amendment. Women were extended the franchise in 1920 with the ratification of the 19th Amendment. In neither of these circumstances, when suffrage was afforded, did either of these bodies lose their identity. Blacks didn't become less black. And while they attained their right to vote in 1870, they still had to fight for civil rights going into the 1960s. And we don't even need to speak at length about the fact that although there is women's suffrage, there is still a lot of women's issues that need to be addressed. Granting our people on this island pursuing the right to vote will make us no less Chamorro, nor will it take away in any fashion the Chamorro's right to self-determination. What bothered me so deeply about yesterday was I was imagining if we took this very session and flashed it back into 1950. And I was imagining to myself, what would the naval governor at the time do? How would he react to know that we were standing up, saying we don't want the right to vote? It is so important for us not to become so consumed with the paths that we want to take. We need to look to our history and continue the work, because the Organic Act that gives us the power to be legislators in here makes us no less entitled to self-determination. Neither does the citizenship rights, the passports, or, God willing, one day, the right to vote.
Thank you very much. Do you still wish to give your remarks with the gallery cleared?
If that's okay. Mr. Speaker, I just want to enter into the record my statement on a bill that I believe forces government to decide for legal age adults while further constricting free enterprise. Mr. Speaker, as the author of the bill, I still maintain that this bill clearly strips away yet another individual liberty of adult U.S. citizens who live right here on Guam. However, the tipping point for me was when I learned that through testimony to Youth Congress and Youth for Youth, in addition to my own 18-year-old daughter, just informing me yesterday morning that she too would support a bill such as 9-34 if she was a senator. But I still think it's important for me to state for the record that if we're concerned about adults abusing their bodies and infringing upon the rights of others, I don't believe you place greater impositions upon the many in hopes that we correct the behavior of a few or even one person. If you're concerned that a person of a certain legal age is legally responsible to do some things and not others, you don't discern which things he or she can do and attempt to regulate that piecemeal. Rather, like the education system, let us treat the whole child. But the difference here is that we're not talking about children, Mr. Speaker. No, we're talking about adults. In this case, we're talking about an attack on a legal framework that allows for persons 18 or older to drive a car, to own a home, to marry, to have children, carry a weapon in defense of a nation, and at the legal age of 18 in some states and jurisdictions, my fellow American, to run for office and govern a people. So if our own modern democratic society has chosen to empower those 18 to 21-year-olds to govern others, but we can't trust them to exercise the rule of law upon themselves, to choose between what's right or what's wrong, then what is it? What is it we're trying to say, Mr. Speaker? What's the message? If we're concerned that there is a grave social ill right here on Guam, then I encourage us to address the cause of the ill holistically and in its totality. For myself, I refuse to believe that it's merely the presence of this vice, a product, that drives one to simply want to pick it up, and on the other extreme, think that when you reach a certain age that you're going to stop at that certain age. At the end of the day, Mr. Speaker, I support an individual's right to make a decision for themselves, to have the freedom to choose and the legal responsibility at 18, to knowingly determine when you can consume what you consume, when you want to consume it, and to also know and have the responsibility of the benefits and the risks that come with that, whether it's health, whether it's your financial risk, safety, or even your own life. I don't smoke. I don't condone smoking. My adult children don't smoke. My 2 minor children don't smoke. And there isn't a tobacco product in my household. And I have to state for the record that I decry any attempt for government to strip away one's liberty to choose for themselves as a duly recognized adult citizen of the United States. Instead, I subscribe to the thought that our children, young adults, and perhaps the author himself can be influenced by the environment. And the environment from those units of measurement is what we must use to take action, namely the home and the community. And if this is the case, that the home, specifically parenting, is one of those greatest predictors of usage and ultimately addiction of tobacco or alcohol or any other item, then let's start there. I'm a father of 4, and I take responsibility, Mr. Speaker, for what happens in my household and for those under my loving care. When my child steps out of line at school, I don't blame the teacher. I certainly don't blame his peers. I blame me. And I do what I need to do to reinforce the lessons of discipline and respect for authority. That's what I do in my house. Similarly, when I don't make wise decisions, Mr. Speaker, like a speeding ticket, I don't blame society. You know, the other night, Mr. Speaker, there was a gentleman who rose before the entire island community and stated that we are in an era of individual responsibility. I can accept that. It's a call to action that universally applies not just to tobacco or alcohol, but to other challenges facing our community. Abuse, theft, crimes against man, and crimes against even the environment. And although I am in support of the measure, it's because a generation has spoken out to petition this body to take action. I am still compelled to suggest that if your principled position, Mr. Speaker, is one based upon the health argument, upon the fragility of the body in its still forming stages between 18 and 21, then what of other things that kill us at a much younger age? What of sugar, sodas, candy, salt-related products, those other items containing other harmful ingredients? Do we not care to apply the same logic? Listen, don't get me wrong. I don't condone the use of tobacco at any age. But you won't see me leverage government to go against an entire legal framework, piecemealing governance. Stop this. No, stop that. Okay, let's do this. Let's encourage that. So I ask our representative members of this legislature, I entreat you, I encourage you, I challenge you to work with these advocacy and behavioral organizations to address the heart of the problem going forward, the core predictors of usage and addiction, socioeconomic status, social bonding, social learning. Students, advocates, parents, everyone and anyone listening, while I stand on the side of individual choice, I am in this fight with you. I think these people behind me know that. I have the brochures, I've passed them out, and I will continue to pass out the brochures at our mobile offices and anywhere we go. But please know that my position on the measure is this. If it were not for a large segment of the affected population to speak out via their governance structures, namely the Guam Youth Congress and Youth for Youth, know that I will not have otherwise used this senatorial seat to leverage power of this body, power which further forces government to decide for legal age adults and which, in my opinion, continues to freely restrict free enterprise. Thank you for the opportunity, Mr. Speaker.
Thank you very much, Senator Castro. Any other member wish to be heard? If not, Mr. Majority Leader, you are recognized. Vice Speaker Tilahi, you're recognized.
Thank you very much, Mr. Speaker. Mr. Speaker, yesterday was an eventful day for us here in the legislature and for all the people of Guam because of the decision that came down from the district court, and because, in the news this morning we found out that the Department of Justice has threatened a lawsuit against the government of Guam and the Chamorro Land Trust Commission, alleging that the complaint will allege, they have threatened that the complaint will allege that the government of Guam, through the CLTC and its administrative director, denied a dwelling to a person or persons because of race or national origin, discriminated in the terms, conditions, or privileges of sale or rental of dwellings, and or in the provision of services or facilities in connection therewith because of race or national origin. And other things, Your Honor, Mr. Speaker. The Department of Justice also in their letter, which was sent to the governor it was sent on January 13 and asked for a response by January 31. They said, "We are prepared to defer filing the complaint for a short period of time if Guam is willing to enter into pre-suit negotiations in an effort to resolve this matter expeditiously in the form of a consent decree to be entered by the court. Although we are willing to discuss the specific provisions, the decree must, at a minimum, provide for injunctive relief addressing the specific violations and preventing future violations of the FHA, including provisions to ensure that land use policies and practices are implemented in a manner consistent with federal law." Well, Mr. Speaker, I would just like to draw the attention of my colleagues to this threat of a lawsuit and their offer to let the lawsuit go away in exchange for a consent decree by the government of Guam. And if we review the consent decrees that the government of Guam has entered into, Mr. Speaker, I think the legislature was very rarely made aware of those consent decrees prior to their being executed, and very similarly in the landfill where the government of Guam had entered into obligations before the legislature had consented or approved those obligations of the government to even in quite substantial amounts. And subsequent to those consent decrees, the legislature passed a law that says this is 1 GCA section 1820. No office, department, instrumentality, agency, institution, board, bureau, commission, council, authority, committee of territorial government, or branch of the government of Guam may enter into any consent decree, stipulated order, or other settlement agreement with any party seeking a claim against the government of Guam that requires the payment of cash, financing, or future financing by the government of Guam without the approval of the legislatura, or a specific appropriation for that claim. Any proposed settlement agreement that requires legislative appropriation or authorization by any office, department, instrumentality, etc., purporting a consent decree, stipulated order, or other settlement with the government of Guam shall be transmitted to Legislature, which by statute may amend, approve, or disapprove the plan or the action taken within 45 days, or said plan or action shall be deemed disapproved. This section shall not apply to claims against the government arising from the Government Claims Act. No settlement in legal proceedings or threatened legal proceedings concerning the government of Guam shall be sealed from public review. I believe that this law was passed in response to the great burden that was placed on the government of Guam without really any consensus or discussion even by the legislative branch. And I think because of this letter from the Department of Justice, I would just like to ask that the legislature take the precaution of encouraging our Attorney General, and in light of yesterday's decision, that the legislature, I've prepared a couple resolutions that would show the legislature, would evidence the legislature's support of an appeal in the Davis case, and the legislature's support of supporting that the government of Guam not enter into a consent decree without approval of the Guam Legislature and the governor of Guam regarding the recent threatened lawsuit proposed by the United States Department of Justice over the Chamorro Land Trust Act. And I believe this is important because of the people that they are threatening to sue. They're threatening to sue the Chamorro Land Trust, which I would assume would be their directors, the board of directors. They name the director. And so I just think that, so I would propose that that my colleagues consider, and perhaps that we take a 5-minute recess to formally introduce and discuss whether we can go back to second reading or go back to motions and consider these two resolutions as resolve to support request that the legislature does hereby on behalf of the people of Guam request the Attorney General of Guam to fight the assertion made by the Department of Justice. Does further support that the government of Guam not enter into a consent decree or other stipulation as to the merits of the case without approval of the Guam Legislature and the governor of Guam regarding the recent threatened lawsuit proposed by the U.S. DOJ. The other one would be that simply that we support that the government of Guam move forward to appeal the ruling of the District Court of Guam to assist in defending the rights of the native inhabitants of Guam. And like an earlier speaker said, these are just part of a bigger parts of bigger strategy by the government of Guam that we as a legislature will have to consider our statutes and see if we're going to amend any of them. But in the interim, I would just, before we get back into a next session, not like to prevent, if it's possible, from anyone entering into a consent decree or giving up any rights, or just to show our support to the Attorney General if she's considering an appeal in this case, that we support that. So if it's not the proper place to make or place in the agenda to make a motion, Mr. Speaker. But so I would ask that could we take a 2-minute recess?
I think we've exhausted the calendar. If you wish to introduce that and circulate it to the members to read, you may. All right, Mr. Majority Leader. Your motion to adjourn.
Mr. Speaker, I'm moving that we go back to motions.
You're making a motion to go back to motions?
Maybe call for a recess, Mr. Speaker.
Recess. Legislature's back in session. Vice Speaker Chalahi, you have the floor.
Thank you, Mr. Speaker. Mr. Speaker, I would move that notwithstanding the rules that we return to motions on the agenda for the purpose of placing resolution number 51-34 and 52-34 on the agenda.
On the motion to revert to motions, any objection? There being no objection, we're in motions. Madam.
Mr. Speaker, I would move that to place resolution number 51 and 52 on the second reading.
Wouldn't that require a notwithstanding motion?
Yes, notwithstanding, Mr. Speaker, notwithstanding the rules, I move to place resolution number 51 and -34 LS and resolution number 52-34 LS on the second reading.
On the notwithstanding motion to place resolutions 51 and 52 on the second reading, is there any objection? Majority Leader, you object? Okay, there's been an objection. All those in favor of placing resolution 51 and 52 on the second reading file, please indicate by raising your hand. Motion passes. Madam Vice Speaker, you recognize.
Thank you, Mr. Speaker. Are we in second reading now?
Well, we are going to have to move to second reading at this point. We're in second reading, and we will have to take these separately, okay? All right, you're recognized on 51.
Thank you, Mr. Speaker. I move that we place resolution number 51-34 LS on third reading. Resolution 51 is relative to supporting that the government of Guam move forward to appeal the ruling of the District Court of Guam to assist in defending the rights of the native inhabitants of Guam. This is nothing different than existing law, Mr. Speaker, and it would resolve that. The resolve says exactly what the title says, that the legislature supports that the government of Guam move forward to appeal the ruling. And this is really just to give support to our Attorney General, who will be considering whether to appeal or not in the next few days. And it's going to be transmitted to the Attorney General only and to the Governor of Guam. And I would ask my colleagues to please support this. I think it does no harm, and it really just states status quo of what our existing law is, and that we support her in her appeal. Thank you, Mr. Speaker.
Any senator wish to be heard on Resolution 51? Senator Nicholas.
Mr. Speaker, may I have a minute? I just need to get some water real quick. May I have a minute to get some water?
Pardon?
May I have a minute to get some water
Okay.
before I begin? Mr. Speaker, may I proceed?
You're recognized.
Thank you, Mr. Speaker. I thought yesterday was heavy, Mr. Speaker. But I mean, things just double up real quick, I guess. A lot is unfolding with respect to this issue. And this resolution 51, I'm going to read the title. I'm actually going to read the resolution because it will be the first time that the public is hearing about it. Resolution 51-34, relative to supporting that the government of Guam move forward to appeal the ruling of the District Court of Guam to assist in defending the rights of the native inhabitants of Guam. And be it resolved by Imina 34 na Legislature ng Guahan, whereas the government of Guam should move forward and appeal the ruling of the District Court of Guam, Davis versus Guam, civil case number 11-00035, in defending the rights of the native inhabitants of Guam. And whereas the people of Guam have waited many years to be heard, and their voices should not be minimized or lessened, as this ruling attempts to accomplish. And whereas the native inhabitants of Guam are entitled to their right to self-determination, and now, therefore, be it resolved that Imina 34 na Legislature ng Guahan does hereby, on behalf of the Legislature ng Guahan and the people of Guam, support that the government of Guam move forward to appeal the ruling of the District Court of Guam to assist in defending the rights of the native inhabitants of Guam. And be it further resolved, the Speaker and the Legislative Secretary attest to the adoption hereof, and that copies of the same be thereafter transmitted to the Honorable Elizabeth Barrett Anderson, Attorney General of Guam, and to the Honorable Edward J.B. Cabo, Imagalahin Guahan, duly and regularly adopted by Imina 34 na Legislature ng Guahan on blank day of month, year. Mr. Speaker, this is a substantive resolution. By our very rules, substantive resolutions are supposed to have a public hearing. And the reason is for us to be able to afford the public an opportunity to weigh in on the matter. Just yesterday, Mr. Speaker, we addressed Resolution 27-34 that spoke to a similar issue with respect to voting rights in our territory. Resolution 27-34 had a public hearing. And for a variety of reasons, it was motioned to go back and have a second public hearing. Now, I would venture to think that the rationale for having a second public hearing is to get even more input. But now we're going to move forward a resolution that has had zero input. Now, don't get me wrong, I'm sure that there will be substantial support for it. But we need to maintain our integrity. You know, one of the first things that I did as chairman of rules, with the rules that we adopted as a body, that the author of this resolution had a hand in drafting, was to try and make sure that we put in rules to ensure more transparency, proper public participation, the necessary protections from this House, doing things about first involving the public. We should involve the public. If the support for 51 is overwhelming, it would give even more support for it because it will be accompanied by a committee report reams thick of testimony from our people explaining why they believe they want to take this course. There may be even oppositional testimony for us to seriously consider before passing such a resolution. The process would be transparent. And I am struggling very hard to maintain as much composure as I can that we would so blatantly contradict ourselves. You know, one of the biggest underminers to the quest for self-determination is trust. people talk about the various status options, and it breaks my heart when I see people talking about status options that will give us more sovereignty, and one of the constant things that get hammered out is, oh, but you can't trust the local leaders of Guam. They're corrupt, they'll steal your money, they'll break the rules to suit themselves. Mr. Speaker, when I was a young boy, there was this really interesting picture book. And for some reason, I don't know why, but I was very fascinated with this one. I don't know if it was a poem or what you would call it, but it had a sequence of pictures and a description underneath the pictures. And in the sequence, it went like this: for want of a nail, the shoe was lost. For want of the shoe, the horse was lost. For want of the horse, the rider was lost. And it wasn't until many, many years later when I grew up and realized that the point of that pictorial was to teach that the little things matter because they ultimately can undermine the big things. This resolution will undoubtedly get unwavering support, but let us bring it before our people, follow our rules, maintain our integrity, and be the example to the plenary power. Let's show them how it's done by being fair to each other, by being fair to our rules and our processes, by involving the public the way we were just advocating yesterday for more of. Now, if this has already been introduced, if we schedule a hearing based on our rules within 5 days, we can have a hearing, we can go into session that very day and honor our process, maintain our integrity, and by the way, have a whole chunk of testimony in support of this. Let us not, in our haste, undermine ourselves. I'd like to make a motion to place Resolution 51 back with the author, that we may schedule a public hearing post haste and involve our people in this process. Mr. Speaker.
There is a motion to send the resolution back to the author. All those in favor? Motion fails. Any other senator wish to be heard on the... You still wish to have the floor? Okay. Senator Nelson?
Thank you, Mr. Speaker. You know, Senator Nicholas was right. Yesterday was a very interesting day with his resolution 27-34. and I myself stated that we must be careful of the implications of rulings of court cases, because essentially it can have an impact in our government. And I did ask my colleagues to not act hastily on that resolution. However, this is a different case. This is a case, this resolution is to support the appeal of the government of Guam to move forward with the ruling of the district court and to assist in defending the rights of the native inhabitants of Guam. It was in today's news. This is the decision of the court. And in a parallel article, it can gravely pose a consequence to the land of the Chamorro people. The Chamorros in themselves, who are native inhabitants of this island. I'm going to read from the Declaration of the United Nations, Article number 8. Indigenous peoples and individuals have the right not to be subjected to forced assimilation or destruction of their culture. States shall provide effective mechanisms for prevention of and redress for any action which has the aim or effect of depriving them of their integrity as distinct peoples or of their cultural values or ethnic identities. Item B. Any action which has the aim or effect of dispossessing them of their lands, territory, or resources. This is essentially what is going on now. We, through this case, are posed as if we are threatened of being dispossessed of our lands. How much longer are we going to wait for the United States to continually tell us that our indigenous rights does not matter, when it clearly states in the United Nations Declaration that it does? Any form or forced assimilation or integration is item D. That's essentially what this case did. We're assimilating to the expectations of the United States law. And so be it. But at the same time, it's infringing on our indigenous rights. Any form of propaganda designed to promote or incite racial or ethnic discrimination against them. From my understanding, this ruling was in favor of Dave Davis on the basis of discrimination. What about the discrimination of the people of this land? I do believe in the integrity of this government, and I do believe in doing what is right and going through the process. However, I do believe that sitting back today and doing nothing would be the greater wrong. Thank you, Mr. Speaker.
Senator Castro, then Senator Torres.
Mr. Speaker, let me begin by saying I fully support the intent of the author of the resolution. But as you can see, I was trying to make sense of when one provision of the rule applies and when it doesn't. And I remember I spoke so fervently on the issue of Resolution 27-34. Yet, we decided to send it back to committee. And notwithstanding my support for the important message that needs to be sent, I'm just wondering, Mr. Speaker, when do we decide when the rule applies for this measure or that measure, And I had to read it for myself. I asked my staff to bring this in because that was very quick. And I'm just reading, it's pretty straightforward. Any question relative to the qualification of a resolution as being substantive shall be determined by the chairman of the Committee on Rules. And I just heard him speak that this is a substantive resolution. And then so I said, okay, that's pretty straightforward. And then I read the subsequent section that says, it shall require public consideration and process in the same manner as a bill. And I was thinking, okay, I'm going to have to assume then that that means you have to have a public hearing. So I'm just making a point, Mr. Speaker, that if we're going to apply the rules, let us apply them uniformly. Thank you.
Thank you. Senator Torres?
Seduce Masti, Mr. Speaker. I'm going to speak very simply from a good common sense point of view because that's what I know best. We are asking ourselves to introduce resolutions on a topic that is still unknown. I question the timeliness of this because we can't ascertain today what the Attorney General's intentions are. In her good wisdom, what the disposition of the matter will be, whether to take it up to appeal or whether to not. We don't understand also whether in fact there's going to be a consent decree that's entered into. And whether we do it today or do it later, I think is relevant because we have a process in place, and I'm not convinced that we should waive the rules that we've set in place, or that something as significant of this shouldn't wait for the normal discourse of a public hearing and input. And so I just want to say, let's be sensible about this. I mean, we've exhausted the agenda, and then suddenly we've moved back to motions on something that occurred yesterday and to which we don't understand what the direction of the Attorney General is or where this is going. So in good measure, let's not be hasty about this, and let's just go through. There's always ways that we can enter our support as a legislative body where we clearly set forth the intent of the legislature, and that could be through an amicus brief. If at that point the Attorney General does in fact file an appeal. To that, I just wish to caution my colleagues that, we're at the start of our Minute 34 in Legislature in Guam. It is always reassuring and soothing if we can have a sense of order about how we are going to run our business of this body going forward. And we can set the precedents now that we are deliberate, that we are informed, and that we are certain and not rash about our decisions. So that is how I propose to conduct my business as one member of 15, and I would implore the rest of the body to please consider, we set the precedent now. Rules are very deliberate. We should be very deliberate and we should be respectful. And although there is great pressure on us, the test of the body is to make sound decisions in good measure. And that's my 2 cents. Sizus Maasi.
Thank you very much. On the resolution?
Mr. Speaker, may I ask for a 1-minute recess, please? 1 minute, maybe even less.
Okay.
Thank you.
Vice Speaker Tulahi, you're recognized.
Mr. Speaker, I've consulted with my colleagues and with the Speaker, and I very much appreciate the commitment and opportunity that's been offered to me that if I could have a public hearing on this, that we could come back into session to consider these two resolutions as soon as possible after that public hearing. Because the reason why we brought this up today is because the next session that was scheduled was the middle of April. And we know that the decision to appeal or not will be made in the next few days. And I just wanted to make sure that if we are going to assure the people of Guam, assure the Attorney General that we support that decision, then I just want it to be timely. And I think 5 days, or if we have to send the hearing notice out tomorrow, it would be 6 days, however that fits into the rules. And if we could have session, as you've committed, I very much appreciate that. And so I would withdraw this resolution based on that, Mr. Speaker. I mean, withdraw it from the agenda today.
Thank you very much. The sponsor having withdrawn both motions, we've exhausted the calendar for the day. Mr. Majority Leader.
Mr. Speaker, I move to adjourn this session, subject to the call of the Speaker.
Any objection to adjourning this session subject to call of the Speaker? Thank you very much. We are adjourned.